Good day and welcome to Epstein Becker Green's webinar, Healthcare in the Crosshairs, OSHA's New Healthcare Enforcement Initiative. Before we begin today's presentation, please be informed that today's webinar is being recorded and the participant phone lines will be placed on mute throughout the program. You are welcome to submit questions throughout the program by using the Q&A feature provided by WebEx. At the end of the program, with time permitting, our speaker will address your questions. You are also welcome to submit questions directly to the presenter following the webinar using the contact information displayed at the end of the presentation. In approximately 2 to 3 business days following the webinar, Epstein Becker Green will communicate the availability of the webinar recording and access to the PowerPoint materials. We are pleased to have a fantastic speaker today. Epstein Becker Green's Valerie Butera is a member of the firm in the labor and employment practice in the firm's Washington, D.C. office. At this time, I'd like to turn the webinar over to Valerie.
Thank you, Claire. Thank you for joining me today. I will be telling you about why OSHA is suddenly targeting healthcare for massive enforcement efforts, what you can do to prepare now, and strategies for successfully navigating an OSHA inspection should OSHA show up at your workplace. Many people have asked me lately, why is OSHA targeting the healthcare industry now? I mean, healthcare has been around for a while. There's a lot of different entities regulating and checking out and ensuring that the healthcare industry is in compliance with various codes. Let me give you a little information about what's going on here. At the American Bar Association's Occupational Safety and Health Law midwinter meeting in March, the Associate Secretary of Labor for OSHA, Dr. David Michaels, announced that OSHA would be targeting healthcare for increased enforcement efforts going forward. Dr. Michaels pointed out that industry averages for healthcare employees injuries, are around 600,000 work-related injuries and illnesses each year, exceeding every other industry in the United States except construction. Although this has been the case for some time, OSHA has not previously put special emphasis on enforcement in the health care industry, with the exception of the National Emphasis Program targeting nursing and residential care facilities, which I'll talk about a bit more in a moment. So why is this happening now? In my opinion, there's a couple of reasons. First, the Ebola crisis gave nurses' unions an incredible platform with OSHA, and OSHA listened. I've been attending these American Bar Association meetings on occupational safety and health law for years now, and this is the first time I can ever recall any nurses' union representatives in attendance. This year, not only were nurses' unions present, but they were voicing their concerns as speakers on panels. And just a quick aside, I would be remiss not to endorse the incredible experience and expertise of Epstein Becker Green's employment, labor, and workforce management practice, which helps employers navigate the complexities of working with unions, including many nurses' unions, on a daily basis. Should you need assistance with a union matter, I would very highly recommend contacting the group. The second reason for this peculiar timing is the so-called general duty clause. OSHA cannot keep up with a rapidly changing workplace and the new hazards that crop up every day. In fact, the agency is notorious for taking years to pass new regulations. Luckily for OSHA, but unfortunately for employers, OSHA can rely upon the general duty clause when it wants to target a particular industry or a type of hazard for which it does not yet have a standard. There are no OSHA standards regulating several of the hazards that OSHA will be focusing on when inspecting healthcare facilities. Liberal use of the general duty clause in issuing citations has always been frowned upon, but OSHA, under the Obama administration, has used it more liberally than ever and makes no apologies for that. Just a couple of months ago, on March 18th, OSHA won a key victory for its policy favoring expansive use of the general duty clause when Walmart Stores, Inc. withdrew its long-standing legal challenge of an OSHA General Duty Clause citation that arose from the tragic trampoline death of a store employee during a Black Friday sales event back in 2008. OSHA is publicly lauding this move. This case has long been considered an important test case to OSHA's policy in the Obama administration to more frequently and forcefully employ use of the General Duty Clause. By accepting this citation, Walmart opened the doors to more aggressive OSHA inspections, complete with compliance officers confident that anything they perceive to be a possible hazard can be successfully prosecuted under the General Duty Clause. On April 2nd, OSHA's Director of Enforcement issued a memorandum to all OSHA regional directors, informing them that the National Emphasis Program targeting enforcement on nursing homes and residential care facilities, which was initially set to expire at the beginning of April, would be extended until replaced by updated guidance. The memorandum went on to explain that in an effort to reduce the excessively high injury rates in the healthcare industry, the agency will continue to use both enforcement and collaborative efforts to address the 5 hazards you see listed here. And that, quote, "We are advising you of the agency's intent to soon issue updated guidance that instructs OSHA offices to allocate enforcement and other resources to additional inpatient healthcare facilities, such as nursing homes and hospitals that have occupational injury and illness rates above the industry average," unquote. Now, while this enforcement initiative focuses on inpatient healthcare facilities, I think that it is entirely possible that the reach of this initiative will spread to other healthcare facilities as well. Employees have become increasingly savvy about their rights, including the right to file an OSHA complaint. Once this new directive begins, healthcare employees working in a variety of settings are sure to learn about it, whether it be through their unions or the media. And they will know that OSHA is looking for these hazards in particular. I think they're going to be more likely to file more complaints if they don't think that their healthcare employers are measuring up whether they're working at an inpatient facility or not. On top of that, there are several ongoing local emphasis programs in which local area offices are targeting enforcement in healthcare, but expanding the reach of their inspections beyond inpatient facilities. I anticipate that of the 5 targets, musculoskeletal disorders will be one of OSHA's primary focus areas. Thousands of these injuries are reported each year in the healthcare industry, but OSHA has had little power to do anything about the problem before because it's never been able to promulgate a workable ergonomic standard. Although there is still no standard, there is the General Duty Clause, which, as I said before, OSHA feels particularly confident in using when issuing citations these days. When justifying its budget proposal for this year, OSHA actually specifically included a request for additional funding to hire more compliance officers to inspect musculoskeletal disorders. Next, we have the spread of infectious diseases. OSHA has been working on a regulation applicable to this hazard, but recently put it on the back burner. Unions were outraged, but what they did not realize is that just last month, OSHA, in conjunction with the National Institute for Occupational Safety and Health, released a respiratory protection toolkit for use by the healthcare industry in an effort to reduce the spread of infectious diseases. OSHA respiratory protection regulations exist, but OSHA plainly states in the text of the toolkit document that it expects healthcare employers to go above and beyond compliance with the regulations. Employers must keep abreast of respiratory protection best practices established by the Centers for Disease Control and other public health entities, and they must employ them. Should they fail to do so, OSHA explicitly warns that in the event of an OSHA inspection, healthcare employers should expect to receive a citation for inadequate respiratory protection programs. Next, we move on to bloodborne pathogens. OSHA's bloodborne pathogen standard has been around for years and has traditionally been the #1 hazard for which healthcare employers are cited. The standard is aimed at preventing employee exposure to bloodborne pathogens that can cause disease in humans. These pathogens include, but are not limited to, hepatitis B, hepatitis C, and HIV. In order to reduce or eliminate the hazards of occupational exposure to bloodborne pathogens, employers must have in place an exposure control plan for the worksite with details on employee protection measures. The plan must also describe how an employer will use a combination of engineering and work practice controls, ensure the use of personal protective clothing and equipment, provide training, medical surveillance, hepatitis B vaccinations, and signs and labels, among other provisions. Engineering controls are the primary means of eliminating or minimizing employee exposure and include the use of safer medical devices, such as needleless devices, shielded needle devices, and plastic capillary tubes. Unfortunately, healthcare settings are particularly vulnerable to workplace violence. OSHA published its updated guidance on workplace violence prevention for the healthcare and social service industries on April 2nd. This guidance is incredibly comprehensive and provides a roadmap for creating effective workplace violence prevention programs in a number of quite varied healthcare and social services workplaces. Here again, OSHA has yet to issue regulations regarding workplace violence prevention, but it can always rely on the general duty clause. Finally, slips, trips, and falls. OSHA relies on a number of regulations, such as its housekeeping regulations, to address this hazard, and it has an e-tool to aid hospitals in preventing slips, trips, and falls on its website. This is pretty low-hanging fruit for an OSHA inspector, so I would anticipate many citations will be issued regarding this hazard as well. The agency has not produced its new guidance yet, but the document is expected imminently. I'm keeping a close eye out for it and will alert the industry of its specific content as soon as it becomes available. Once the new compliance directive is released, I anticipate a sharp rise in the number of OSHA inspections taking place at healthcare facilities. This seems to be one of OSHA's pet projects. And you really need to be prepared because roughly 70 to 80% of OSHA inspections lead to citations. So what can you do now to improve worker safety and significantly decrease your chances of receiving an OSHA citation? I highly recommend conducting an internal safety and health audit, particularly if you have one or more facilities with high injury and illness rates. This will help you spot trouble areas and address them, protecting your employees and helping you avoid running into trouble with OSHA. But be careful in how you conduct these audits. Many compliance officers begin inspections and immediately ask for all audit reports, including your internal audit reports. The compliance officers can then use your own audit reports against you, relying upon the results as a guide to possible OSHA violations in your facility. But if you work with counsel in arranging your internal audits, the resulting audit reports are protected under the attorney-client privilege. A couple of years ago, one of my clients had hired a professional third-party auditor to conduct an internal inspection of its facility so it could identify areas for health and safety improvements. The client did not hire the auditor directly, but through counsel as it was seeking OSHA compliance advice. When OSHA came to inspect its facility a year or so later, compliance officers came in and asked for that audit report. We advised the client not to deliver the report to OSHA as we believed it was protected by the attorney-client privilege. OSHA then sent a subpoena to the third-party auditor seeking a copy of the report. The auditor found this strange and called us. I moved to quash the subpoena. The administrative law judge refused to do so, so I petitioned for interlocutory review of the issue by the Occupational Safety and Health Review Commission. The commission granted the petition for review, adopted our client's position, and established new law protecting internal audit reports when created excuse me, to help outside counsel advise clients on OSHA compliance. So if you find yourself needing to conduct an internal audit of any of your facilities, I highly recommend that you do so with the aid of counsel in order to ensure that your audit reports are protected from disclosure to OSHA. Before we get to the nuts and bolts of the inspection itself, here are some more actions you can take now to prepare in case OSHA chooses to target your worksite. First, talk to your employees, through the union if your worksite is unionized or directly if there is no union at the worksite. Encourage an open dialogue with your employees about safety. They should feel comfortable approaching management with health and safety concerns at any time. They're on the front lines of your workplace and often the first to identify potential problems. You should also include them in your efforts to find a solution. This not only increases employee engagement in your health and safety program, it demonstrates your commitment to ensuring the health and safety of your employees. If you have not done so already, you should consider establishing a safety committee that includes union and/or employee representatives to evaluate safety programs as they're written and implemented, and review and discuss workplace incidents and near misses. I also highly recommend that you truly dig into the content of the healthcare page on OSHA's website. Here you can find the standards, the new publications and best practices that I discussed a moment ago, and get a good general understanding of what OSHA expects from healthcare employers. You should also ensure that likely areas of concern during an inspection have been addressed before any inspections begin. Obviously, this starts with compliance with OSHA's standards and best practices regarding the 5 target areas we discussed previously. But in addition, you should ensure that you have adequately documented employee training, your employees can demonstrate that they understood their training, and you should also get your injury and illness records in order. OSHA will usually focus on these elements as part of any inspection. Next, it is critically important that if you have more than one facility, you take steps to ensure that all of your facilities are in compliance. Often, OSHA selects employers that give it the potential for more bang for its buck. That is, employers with more than one facility. If OSHA finds that even one worksite among a group of worksites owned by the same employer has a high rate of injuries and illnesses, it has directed all of its compliance officers to conduct inspections at one or more of that employer's worksites. Often, the types of problems identified in an inspection of one facility are found at inspections of the employer's other worksites as well. OSHA can issue costly repeat citations to the employer by inspecting multiple facilities, finding similar issues throughout the facilities, and issuing repeat citations at one facility based upon a similar citation having been issued at another facility. So if you find yourself dealing with an OSHA inspection at one of your facilities, you should not be at all surprised if OSHA shows up to inspect your other facilities as well. Not only does this allow OSHA to issue a greater number of citations to the employer, it also increases the penalties that it can demand. A citation classified as serious has a maximum penalty of $7,000, but a citation classified as repeat has a maximum penalty of $70,000. And the fun doesn't stop there. OSHA is pursuing more and more corporate settlement agreements, or CSAs. CSAs give OSHA the option of requiring employers to take actions at the worksite where they have received citations plus all of their other worksites. CSAs are intended to give OSHA the flexibility to correct a pattern of noncompliance with various OSHA standards across multiple worksites. These agreements can be either national or regional in scope. Although OSHA states that CSAs should be directed at areas of health and safety that have been the subject of a citation, the agency will also consider going beyond the subject of the citations issued and include additional safety and health program enhancements. Some examples of program enhancements sought by OSHA when negotiating CSAs include a corporate-wide injury and illness prevention program, requiring a uniform ergonomics program at all locations, requiring uniform personal protective equipment requirements at all locations, and hiring a third-party consultant to conduct periodic safety and health audits of the work sites, make recommendations of how to mitigate identified risks, and require the employer to implement whatever those recommendations are at all of its work sites. As you can see from the language of the statute that empowers OSHA to conduct inspections, OSHA inspections may take place during regular working hours and should be conducted in a reasonable manner. In the case of inpatient healthcare settings, however, it's difficult to determine what will be considered a reasonable inspection during regular working hours. It is entirely possible that compliance officers will be permitted to inspect inpatient facilities day or night. But by planning in advance for an inspection, you can make the inspection run more smoothly, gain greater control over the inspection, create a positive impression on the inspector, and limit the number of citations that you may receive. In order to fully understand what to expect during an OSHA inspection, it's important that employers understand OSHA's rights when conducting them. You should fully expect compliance officers to take advantage of most, if not all, of these rights during any inspection. Notably, if you refuse to consent to OSHA's right to inspect records, collect evidence, or conduct interviews, OSHA may subpoena your cooperation. Generally, I recommend consenting to these actions by OSHA, but keep in mind that you can use your consent as a negotiating tool. If, for example, OSHA seeks to interview numerous employees during their work shifts, essentially bringing your workplace to a standstill and making it impossible to properly care for patients, by all means, push back vigorously to negotiate a reasonable, non-disruptive interview schedule. Importantly, employees and employers have rights during an inspection too. Your employees can file complaints with OSHA at any time, including while the inspection of your facility is taking place, and you may not retaliate against them for doing so. Should you choose to retaliate, you do so at your peril. OSHA has significant whistleblower protections in place, and successful whistleblower claims can result in penalties in excess of $1 million. Your employees have the right to participate in nearly the entire inspection process, which I will discuss in more detail later. It's important to emphasize here that management has no right to participate in OSHA's interviews of any kind of non-managerial employees. And a significant and controversial additional right that employees have now is to designate a representative to participate on their behalf with OSHA. OSHA has specifically explained that this representative can be a union representative, even where the worksite is not unionized. Employees and union organizers frequently use this option as a way to open the door to unionization at the work site. And here we have employers' rights in an OSHA inspection. OSHA may only inspect at reasonable times, and the scope of the inspection must be reasonable. You may demand a warrant before inspectors enter the premises, but I almost universally discourage this tactic, and I'll talk a little bit more about why about that in a moment. You should demand an opening conference where you will negotiate the scope of the inspection with the compliance officer. If the inspection is due to a complaint, ask for a copy of the complaint. Negotiate the scope of the inspection to only address the specific complaint or question. I've heard from many clients lately that compliance officers have been terribly difficult when negotiating the scope of inspections. So do be prepared for some pushback, but remember that you have rights here. And a wall-to-wall inspection is usually only required when all 4 of these criteria are met. An employee complaint is received, the business is in a high injury rate industry, the employer has a lost workday rate at or above the national average, and OSHA has not carried out a complete safety inspection of the facility within the past 2 years. In any event, a very effective tactic you can employ in negotiating the scope is to waive the warrant requirement and consent to the inspection, but only after negotiating an acceptable scope at your opening conference. These should be employers' primary goals during an OSHA inspection, and I'm going to briefly walk you through the basics of how to achieve these goals. Before OSHA ever shows up at your facility, you should establish an inspection team and inspection protocols. Part 1 is preparing a notification plan, identifying who must be informed and by whom of the start of an OSHA inspection. This should include senior management, supervisors, and your OSHA council. You should also designate and train an inspection team. Your inspection team could include a number of different people within your organization or just a few who play many roles. Specifically, you may want to designate a spokesperson. An important person that you will be designating as a walk-around representative. This person will determine the best route for escorting the compliance officer through the facility and will accompany the compliance officer during the inspection. And let me just take a moment here to talk about the walk-around route. OSHA employs what's known as the plain view doctrine. This doctrine permits the agency to investigate potential hazards beyond the scope of consent or warrant if the compliance officer observes in plain view from an area within the scope of the walk-around any kind of potential violation. So plan your most direct route to the inspection area as possible and avoid providing a full tour of the facility. You may also want to designate an escort. This person is similar to the walk-around representative, but is charged more with dealing with the compliance officer before and after the walk-around. For instance, the escort could take the compliance officer off the premises for lunch rather than permitting the compliance officer to eat on-site with employees who may be disgruntled and point a compliance officer to additional potential hazards. If appropriate, you may want to designate a union liaison or a contractor liaison. You'll definitely want to have a photographer. Anytime OSHA takes a picture of anything in your facility, you want side-by-side shots of everything that you see the compliance officer photographing. You'll need a document coordinator. You're going to be asked for documents, and you're going to want to carefully track what OSHA has received. You'll need to designate a sampler. Much like your photographer, a sampler is going to take samples of anything that OSHA takes samples of. And finally, an interview representative. This person will sit in on management interviews and inform non-managerial employees of their interview rights. You want to ensure that you have trained your inspection team thoroughly and that they understood the training. The team should know who to contact, OSHA's inspection rights, employers' and employees' rights, the OSHA standards, and how to control the flow of information. You're also going to want to provide the team with inspection tools and ensure that they understand how the tools are to be used. These could include a camera, a video camera. You're going to want to provide them with a contact list, a document control log, sampling tools, document labels, and cover sheets for documents produced to OSHA. And I want to circle back for a moment on the warrant versus consent issue. If you ask for a warrant, this puts a huge restraint on OSHA and could lead to retaliation in the form of a more aggressive inspection. So as I said before, I do not generally recommend asking for one. Plus, if you consent to the inspection, you appear cooperative, which is usually quite helpful when dealing with compliance officers. It will usually give you more power to minimize business disruption and just have an easier to manage inspection. Here are the 5 major stages of an OSHA inspection, which we'll discuss in turn. We begin with the opening conference. So what are the best strategies for negotiating or navigating the opening conference? First, you should insist on having one in the first place. OSHA is not necessarily going to offer it up, but you have the right to it, and it's critical that you demand one. You should select the location and the participants in advance. If one of your designees is not immediately available, you need to tell that to OSHA, and they need to wait until the person can get there before they can start the inspection. If you include your outside counsel or a manager that may be located in another state, that may mean a several-hour delay or that the conference cannot commence until the next day because the person is far away. OSHA won't take this well, but you have this right, and you should use it. They want to get out there on the floor and start inspecting before your employers know that they're there, or employees know that they're there, but you should use this right and absolutely don't shy away from it. You should ask for the anticipated duration of the inspection. Work interruptions are supposed to be kept to a minimum by OSHA. Ask for the purpose and the proposed scope of the inspection. This is also the time you're going to want to introduce your inspection team to the compliance officer and explain how you intend to manage your document production. Advise the inspector of facility safety procedures and require that the inspector follow them. Sometimes they actually will try not to follow them, so you need to keep an eye on them. Establish an interview protocol. For example, arrange employee interviews such that they do not interfere with the employee's workday. You should arrange for daily closeout meetings where you can ask the compliance officer about any concerns that they may have identified that day and discuss how you may address them. Consider proactive presentations regarding the compliance officer's concerns. It's much easier to avoid erroneous citations before they're issued. So if the compliance officer expresses concerns, you may want to put together a presentation to demonstrate how the employer is in compliance to share with the compliance officer at the next daily closeout meeting. Arrange to screen any photos or videos taken by the compliance officer for trade secrets and other legally protected private information such as PHI. You need to mark these documents as confidential so that the general public cannot access them by way of FOIA requests once your inspection and possible litigation come to an end. While the opening conference is taking place, you're well advised to have your management personnel conduct a walkthrough of the facility to clean up disorganized work areas, ensure employees are wearing appropriate personal protective equipment, ensure that they're working safely and complying with safety programs and policies. And you should also make sure that employees, temporary employees, and contractors on your site are advised of OSHA's presence. OSHA will likely gather many documents both during and after the inspection. You should insist that document requests be in writing, except for your OSHA injury and illness record-keeping forms. OSHA is entitled to these under law without the need for any formal written request, and you must produce these logs within 4 hours or you are subject to a citation. Generally, you're well advised to produce whatever OSHA asks for voluntarily, but in some circumstances, such as the internal audit reports I discussed earlier, you should demand a subpoena. So if possible, it's always best to check with counsel before you produce anything to OSHA so that counsel can ensure OSHA does not receive anything that it may not be entitled to. You need to keep a copy of all the documents that you produce to OSHA and maintain a document control log. Your document control log should include what the request was, when it was made, who was assigned to produce the document, when it was produced, and whether it contained any legally protected information. Many employers are using electronic programs to train their personnel these days, so should OSHA ask you for a copy of your training materials, and they usually do, and your materials are electronic, usually you're not going to have a license to reproduce them for OSHA. Should this issue come up, simply explain the situation to OSHA and invite them to come view the training materials at your workplace, but make sure that they understand that it is for the one and only purpose of reviewing your electronic training materials. Next comes the walk-around inspection. First and foremost, you must escort OSHA at all times. You do not want them running around your facility looking for hazards. Gather as much information as you can about the focus of the inspection by paying close attention to the compliance officer's actions and questions. You want to control the flow of information. Give no information that has not been specifically requested. Ensure that the compliance officer fully understands your safety rules and follows them. If sampling is going to take place, ask for notice and take identical samples as the compliance officer. Immediately correct alleged hazards identified by the compliance officer if you can, but don't admit any kind of violation. Do not argue with the inspector about whether something is a violation. Make sure not to demonstrate work tasks or operation of equipment not otherwise scheduled pursuant to the ordinary course of business. And finally, be sure to take detailed notes of everything that you see and hear. OSHA is also going to want to interview your employees. You should arrange employee and management interviews in advance to minimize business disruption. Should you notice the compliance officer talking to an employee during the walk-around or anywhere else outside of the interview room, you should interrupt the conversation if it lasts more than just a few minutes. The compliance officer is expected to be reasonable and should request an interview with this employee if he or she feels that it's necessary to continue the conversation. Again, employers have no right to participate in non-managerial employee interviews or to designate representatives to participate. Basically, beyond scheduling, employers need to be hands-off for this part of the inspection. Non-managerial employees may certainly voluntarily share with you what they said to OSHA, but they are under no obligation to, and you should not make them feel like they need to. Here again, you may not discriminate or retaliate against an employee for participating in an OSHA interview. One element of proving an OSHA violation is employer knowledge. Generally, the way OSHA gets there is by imputing supervisor or manager knowledge to the employer. Accordingly, you should ensure that management interviews in particular are scheduled in advance so that you can consult with management, prepare them for the interview, and not find yourself taken by surprise if they know something relevant that you don't know. The only time a supervisor or manager's knowledge will not be imputed to the employer is if it was the supervisor or manager himself or herself who violated the OSHA standard. Here are your main objectives in preparing your management and all other employees for OSHA interviews. You need to share this information with everyone from your facility who will be interviewed by OSHA. Explaining to your employees that they do not have to sign anything during the interview, including the compliance officer's written account of what the employee said, is extremely critical here. Signed employee statements carry a lot of weight, while unsigned statements are not terribly useful for OSHA. Therefore, compliance officers tend to really push on employees to sign these statements. Of course, you should not discourage employees from signing them. Just make sure that they understand that they have every right not to sign anything. Also remind them that I don't know and I don't remember are perfectly acceptable answers if true. You should also remind employees of applicable safety rules and safety training that they have received. Use records to refresh their memory if necessary. This is a critical step because OSHA is going to ask your employees if they understand your safety policies. They're going to ask them about training, refresher training, and whether they understood the training. I see some kind of failure to adequately train citation in almost every case I handle, and it often stems from an employee reporting during an interview that they were not trained or failed to fully understand the training that they received. A side note here, if you do not already keep impeccable training records, you should begin to do so now. They are extremely helpful in defending these very common citations. Once the inspection is over and OSHA has determined whether it will issue citations, a closing conference will take place. You have several important goals of the closing conference. First, you want to correct obvious errors and misinterpretations, at least to the best of your ability. I've found this to be challenging with a lot of area directors. They are pretty determined that they're right, when often that's not the case. Identify alleged violations that you've already corrected. Request time to offer additional information in your defense. Ask about citation classifications and penalties. Make sure not to offer any commitments about abatement. This is very important because you need to go back and think about the feasibility of what OSHA is requesting you to do. Some abatements can be cost prohibitive, and often abatements take much longer to implement in practice than you might have imagined when you're sitting in the closing conference. And again, take detailed notes. If OSHA decides that a citation should be issued, it has only 6 months to do so. Often, OSHA will take this entire 6-month period to study its findings and determine whether an employer will be cited, and if so, for which hazard. Should an employer receive a noteworthy citation, that is, one that's characterized as willful or repeat, one that carries with it a high penalty amount, or cases involving OSHA's pet projects, which I would have to say that I think the healthcare initiative is one of its pet projects, you should be prepared for OSHA to simultaneously issue a scathing press release regarding the employer's apathy towards employee safety and health. Be prepared to respond appropriately. You have several options upon receiving an OSHA citation. Be mindful that once you receive a citation, you need to move very quickly. Contact counsel immediately to review and discuss the citation with you, and should you choose to file a notice of contest, to prepare your notice of contest for you. Your counsel has only 15 days from your receipt of the citation to file your notice of contest. Sometimes employers think that because the penalties connected to OSHA violations are small by comparison to those issued by, say, the EPA and other regulators, that they should just pay the fines and OSHA will go away. But this thinking is fatally flawed. OSHA penalties usually range from about $3,000 to $7,000 per alleged serious violation, with $7,000 being the ceiling. OSHA can get much more money out of an employer, however, if it chooses to inspect the same work site later and finds either repeats or failure to abate. As a reminder, a repeat citation may be issued if OSHA finds an employer has committed the same violation in either a location OSHA inspected previously or at a different location owned by the same employer. And again, the penalty for repeat citations can be as high as $70,000. If OSHA finds that an employer has failed to abate a prior violation, it may demand a civil penalty of up to $7,000 for each day the violation continues beyond the prescribed abatement date. There are other technical OSHA considerations, such as possible inclusion in the Severe Violator Enforcement Program, that should be considered. But I don't want to overload you with information today, and if we get into that, Val will certainly do it. I'm happy to discuss details about that program with you offline if you'd like to learn more. Finally, employers should also consider the possibility of related civil suits. If an employee is injured in relation to something that OSHA has cited an employer for and brings a civil suit, Most jurisdictions allow OSHA citations and judgments in as evidence of negligence by the employer. A few jurisdictions even credit OSHA judgments as evidence of negligence per se. Although we've covered a lot of ground today, there are even more steps that employers can take to prepare for and successfully navigate an OSHA inspection. If you would like a copy of Epstein Becker Green's complimentary OSHA inspection checklist, which will walk you through every step of the process with additional detailed advice, please contact me and I'll be happy to send a copy to you. Epstein Becker Green releases numerous communications as a means to keep you informed, and here are several examples. If you're not receiving our e-communications and would like to receive future issues, please contact our office. And be sure to visit and subscribe to Epstein Becker Green's OSHA Law Update, Health, Employment, and Labor, and Health Law Advisor blogs to receive timely updates concerning all facets of OSHA, healthcare, and the intersection of these areas. Reach out if there's a topic you want to learn about, and we are happy to either send you a blog that we have already written, or we will be happy to write a blog on that topic for you. And now we have time for questions.
Thank you for joining us. We're going to take a few minutes. We got a couple of questions.
Right.
So first question is the voluntary protection program worth enrolling in? Valerie?
It is definitely worth enrolling if you're talking about OSHA's program where they come in and help you comply. The problem with it is it's extremely difficult to get into the program. OSHA acts like, when you read its website, like it's very easy to get into that program, but you have to jump through lots and lots of hurdles, and it's extremely costly. So it's sort of a cost-benefit analysis. You have to determine really how much work. I would suggest in making that decision, going in, determining how much work would really be needed to make it into the program and decide whether that is sort of an effective way for you to control costs when it comes to health and safety.
Our next question, what is the best way to audit the third-party provider who is the OSHA consultant?
Audit the third-party provider. Oh, I see. Okay. Okay. I would suggest, I would sort of treat that person like a contractor. And with OSHA, what that means is you go, you collect information about their experiences. I would think if you're working with a third-party OSHA consultant, that they themselves probably don't have any kind of issues with OSHA, but you do want to know what their policies are, what their experience is. You want to know that they have an absolutely comprehensive understanding of the issues in your organization and the type of work that you do.
And this will be our final question. Can an audit be conducted with an attorney that works inside of the organization, or does it have to be an outside attorney?
I get this question a lot, and unfortunately, I know from a cost-saving perspective, this is not the answer people are going to want to hear, but it does have to be your outside counsel. That's specified in the case law on this, so it is absolutely outside counsel is required.
Thank you for joining us. This concludes today's webinar. In approximately 2 to 3 business days following this webinar, Epstein Becker Green will communicate the availability of the webinar recording and access to the PowerPoint materials. You're welcome to submit questions directly to Valerie at her contact information on the screen. Thank you and have a great day.